Good morning. Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. Of course, welcome those who join us on our heritage.org website on all of these occasions. For our in-house guests, we always appreciate that last courtesy check that our mobile devices have been silenced or turned off. For those watching online, you're reminded you're welcome to send questions or comments at any time, simply emailing speaker@heritage.org. And of course, we will post today's program on the Heritage homepage for everyone's future reference as well. Leading our discussion is John Malcolm, who serves as Vice President of our Institute for Constitutional Government, as well as Director of our Edwin Meese Center in Legal and Judicial Studies. Prior to joining us here, he served as a Deputy Attorney General in the Criminal Division at the Department of Justice. He has also been an Executive Vice President at the Motion Picture Association of America, as well as served as the General Counsel at the U.S. Commission on International Religious Freedom. Please join me in welcoming John Malcolm. John?
Thank you, John. Quick correction, and I probably wouldn't even bother, except for Mike Chertoff is actually here. I was a Deputy Assistant Attorney General. Deputy Attorney General would be quite the promotion. But in any event, on February the 27th, the Supreme Court is going to hear oral argument in the case of United States versus Microsoft. The case actually involves the scope of the Stored Communications Act, which was a law that was passed by Congress in 1986 when the World Wide Web did not exist and email was in its infancy. This law gives the government power, if it obtains a warrant, to require an email provider to turn over the content of emails stored on its servers. This case, however, provides an interesting wrinkle. What if the email provider is located in the United States, but the emails are stored overseas? In this case, the government obtained a warrant requiring Microsoft to produce emails from the account of one of the targets of the investigation. Specifically, it was a drug trafficking investigation. The warrant was served on Microsoft at its corporate headquarters in Washington State, but the company refused to provide the emails because they were stored on a server in Ireland. Microsoft has acknowledged that the emails are within its control and that it could retrieve these emails from its server in Ireland and produce them at their headquarters in Washington. But the company has argued that it shouldn't have to do so because there's a presumption against extraterritoriality, meaning that normally the reach of U.S. law enforcement stops at the water's edge. Microsoft has also argued that producing these emails would violate Irish law and European Union laws, thereby putting Microsoft between a rock and a hard place about the potential overseas ramifications to the company if it were to violate these laws in order to comply with the warrant. The Second Circuit Court of Appeals sided with Microsoft, and now the case will be heard by the Supreme Court. The outcome of this case could have a dramatic impact on domestic law enforcement investigations and on international relations. Congress is also considering various legislative proposals to address or at least ameliorate this problem. On the House side, a bipartisan group of congressmen recently introduced the International Communications Privacy Act, or ICPA, and a companion bill was recently introduced in the Senate, the Clarifying Lawful Overseas Use of Data, or CLOUD Act. Now, astute observers will already have noticed that we are one speaker down, and that is because Congress has scheduled votes this morning. So because of that, I'm going to introduce first Congressman Warren Davidson. He'll have an opportunity to make remarks, and then he'll stick around as long as he can, so when he ducks out, please don't take it personally. And then I'll introduce our other two speakers, and we will go ahead. So Congressman Warren Davidson is from the state of Ohio. After high school, he enlisted in the Army, where he served for 12 years. His work ethic and leadership skills earned him an appointment to the U.S. Military Academy at West Point, where he finished near the top of his class. He subsequently returned to Ohio, where he helped restructure and dramatically expand his father's manufacturing business, and then he started other businesses. He eventually went to business school and got an MBA from Notre Dame. In 2016, he won a special election to fill the remainder of the term of outgoing Speaker of the House, John Boehner, and he was reelected later that year to a full term. He serves on the Financial Services Committee. Please join me in welcoming Congressman Warren Davidson.
Thanks a lot, and it really is an honor to be invited to speak about just about any topic here at Heritage. But this is a really interesting one. It intersects with a lot of topics in law and a lot of topics that really have even national security ramifications. We're in the midst of a lot of discussions about warrants related to FISA. We deal with a number of things on the Terrorism and Illicit Finance Subcommittee that I'm part of, that's part of Financial Services. And so while this relates to email privacy, it also highlights the kind of broken nature of some of our laws. This law could not have foreseen everything that was going to happen after 1986, even with technology. And the way that it's been applied, it leaves us vulnerable to court decisions. So it really is, the bottom line is it's time for Congress to act. There are a number of bills that are out there that were already highlighted in some ways, but it also talks a little bit about privacy, exactly who is protected by the 14th or by the Fourth Amendment. And as you look here, a warrant is clearly been issued, but there are large gaps where warrants aren't even required. FISA has sections where there's no warrant required. There's been cases where geolocation is not required. And in the case here, for emails that are older than 180 days, the way this law has been applied, well, there's not a warrant required for that either, which is staggering, I think, to think that if you had written something down in a journal 181 days ago, that it wouldn't be protected by the Fourth Amendment if it were laying on your desk, but somehow, since you sent it by email, it has an expiration date. I don't see an expiration date on the Fourth Amendment, so I hope we rapidly remedy that in law. So the body that comes here, you think about it from the perspective of law enforcement, and you think, so we can be duped by any criminal smart enough to say in a drop-down menu, please store my data outside the United States. It highlights the importance that law enforcement be able to access things when they go through the proper channels and provide the evidentiary hurdle to get a warrant. And Microsoft clearly says they have access to be able to do this. There's cases that spill over related to Google, related to, frankly, anybody that stores data. And so I think we would benefit from a healthy dialogue about this. And frankly, this is one of the reasons where I wanted to come and say, here's a number of ideas, beliefs, core principles that come to a head. And I think it'll be an interesting dialogue about where the individual's protections under the Fourth Amendment begin and end, and what happens to the data. Is the data American data because it's an American's data, or is it Irish data because it happens to be sitting on a server in Ireland? And I think my default position is, in every case, it's your data. You may have terms of service that you have a relationship with the service provider, but if it's your data and you're an American, then the warrant would apply to you. If it's your data at all, if it's not your data, then it's Microsoft's data. And then it comes to a head there. So then you have the international treaty ramifications, and we are at conflict with whose law is covered there. If an American traveled to Ireland and left their journal laying in Ireland, as long as it wasn't more than 180 days old, apparently, then it would be clear that Irish law covers it. The piece of data is laying in a safe in Ireland. So it's going to be really interesting how we work through this. I do think that it's important, however the court decides, that we, as Congress, settle this in law, not just a series of somewhat incoherent court decisions. And the massive gaps related to geolocation, the 180-day expiration date on the Fourth Amendment, and a number of other things in our electronic data privacy and security issues highlight why Congress really needs to act and provide legislative certainty. I would hate to be Microsoft or Google or somebody else and try to figure out how to comply with this hodgepodge of court decisions. So thanks for your interest in being here or watching online, and I really look forward to the expertise that has been brought to bear here. So thank you.
Thank you, Congressman, and hopefully you can stick around for a while. So the next speaker we'll hear from is the Honorable Michael Chertoff. Mike is an honors graduate from Harvard College and Harvard Law School. After graduating from law school, he served as a law clerk to Associate Supreme Court Justice William Brennan, and then he embarked on a successful career as a federal prosecutor, including serving as the United States Attorney for the District of New Jersey. He was also successful in private practice and as a special counsel for the Senate Whitewater Committee. From 2001 to 2003, Mike was the Assistant Attorney General in charge of the Criminal Division at the Department of Justice, where I had the privilege of serving as one of his deputies. In 2013, he was nominated and then confirmed to be a judge on the Third Circuit Court of Appeals.
2003.
I'm sorry?
2003.
I thought I said 2003.
This is 13.
Oh, sorry, 2003. Well, maybe
would've been
2003, yes, 2003. However, in 2005, the executive branch beckoned to him once more, and he left the bench in order to serve as Secretary of the Department of Homeland Security, where he served until 2009. He is the co-founder and executive chairman of the Chertoff Group, which provides services to clients on risk identification and mitigation and on crisis management. And he's also a senior counsel at Covington & Burling and a member of the firm's White Collar Defense and Investigations Practice Group. After Mike speaks, we will then hear from actually my newest colleague at Heritage as of a week or two ago, Klon Kitchen. He is the new Senior Fellow for Technology, National Security, and Science. Klon got his undergraduate degree in philosophy and theology from Bryan College, and then a master's degree in strategic security studies from the College of International Security Affairs at National Defense University, where he has also taught graduate studies as well. Immediately prior to joining Heritage, he served as a national security advisor to Senator Ben Sasse of Nebraska, and prior to that, he spent over 15 years in the U.S. intelligence communities, working on cyber, terrorism, counterproliferation issues at the Defense Department, the CIA, and the Office of the Director of National Intelligence. Mike, the floor is yours.
John, thank you, and thanks for hosting this, and glad to see all of you. Just full disclosure, both at Covington, at my consulting firm, we do work with Microsoft, and we work on this issue, and I've published, in fact, some op-eds about this, including one on Monday in the Wall Street Journal. This is a feature of a larger set of complicated issues that arise out of the fact that the world still has physical boundaries, but the data does not. And the technology has driven us more and more to moving in the direction of allocating the data and storing it wherever it is most technologically convenient and where you have things like power and kind of safe physical environments. And therefore, there creates a tension between the way the data is handled and the way governments still want to operate according to their sovereignty. The challenge posed by the Microsoft case is one element of that. Obviously, you have a company located in the United States, headquartered in the U.S. with a global reach. In this case, the data in question is sitting on a server in Ireland. It is a U.S. person whose data is the data owner. And one of the analogies that came to mind early on when this situation presented itself is this like the bank secrecy cases we used to have in Switzerland, where you had a Swiss bank doing business in the United States, and you wanted to have bank records, and they said, wait a second, we're subject to U.S. law, and a judge would say, no, there's a warrant, you have to comply with the warrant, it's bank records, turn them over. Is that what we have here? Microsoft records are like bank records and you turn them over. I would argue no. This is more like a safety deposit box. If you were a Swiss bank and you had your main headquarters in Geneva, but you were doing work in the United States, and you got a warrant to search a safety deposit box, and the box was located in Geneva, it would not be the bank's records that were being the subject of the search warrant. It would be the records of an individual and property that was housed in another country. And you'd have to go to the Swiss authorities to get their equivalent of a warrant to do the search. And so the argument made by Microsoft here is essentially it's a safety deposit box. The data is on a server. In order to execute a warrant against that data, given where it's located, you have to go to an Irish court. Now, this door swings both ways, and many of you will know that there have been cases in the past where, particularly in Brazil, a couple of times judges have demanded that data be turned over that's housed in the United States, And when that was a problem under U.S. law, the judge threatened to throw the local representative of the company in prison. So the challenge when you deal with these international questions is what's sauce for the goose is sauce for the gander. And you've got to have a rule that's consistent along both. The good news is I think Congress is now focused on this issue, and we need to start to think about what are ways we can have a regime where we have a coordinated and even playing field on these issues of data. I think the companies are agnostic as long as they get two things: clear legal authority, and they're not subject to inconsistent legal obligations. What some of this new legislation does is it would treat, for example, U.S. owners of data as subject to a warrant no matter where the data is being held. But if you're a foreign owner, then you have to go to the country where the data is housed in order to make sure that you can execute the warrant against the data. And that would be one consistent way, provided that the country we're dealing with has a relatively similar set of protections as we have. That's frankly going to narrow the aperture as to the number of countries that are going to be subject to this kind of bilateral relationship. We've got an agreement with the Brits, which is likely to satisfy this. I wouldn't hold my breath for Russia or China. And then the interesting question becomes how that's going to work with Europe. I will say there's an interesting set of issues that still remain. What does it mean to say the data isn't Americans? If you think about the way data is generated, there's the owner or creator of the data. Then there's the person who acquires the data or owns it after it's created. And then there is the subject of the data. And those can be three different people with three different citizenships. And one of the policy questions to be decided is, in those cases, which is the citizenship that determines? If I'm, for example, an American citizen and my very confidential stuff is being held on a server somewhere else, but the person who actually put the data there, who, quote, owns the data, is a foreigner, is it the foreigner's citizenship that's going to control, or is it my citizenship, or vice versa? So while I think these bills that we see in Congress are a good start, I do think we're going to see a recurrent problem of reconciling the divergence between physical reality and virtual reality in this context and a whole host of other contexts. So a very interesting discussion.
Good choice, Congressman. Good morning, everyone. I'm fortunate to, I think you're going to hear some similar themes from me, and that encourages me. The fundamental tension at the Microsoft v. Ireland lawsuit is the hybrid nature of the internet itself. So on the one hand, the infrastructure of the internet is a physical construct that exists in time and space and within physical borders of sovereign countries, and as such, legacy notions of sovereignty and territoriality are in play and often are even decisive in the conversation. But as the Secretary just mentioned, the information flowing throughout this infrastructure exists in a state that challenges these legacy notions, because the data can simultaneously be in multiple jurisdictions, either in part or in whole, with their own jurisdictions and legal regimes governing them. And as I said, this is an inherent challenge of the internet. It's how the internet works. And so the fundamental reality that you're watching play out here is that law enforcement now is having to deal with the reality of the internet and work within a world that is far more ambiguous and at times constraining than what they might prefer or what they have certainly grown accustomed to. Now, recognizing this reality is not at all the same as advocating for it. It's simply recognizing reality as it exists. This becomes most uncomfortable for us in the context of terrorism and other serious crimes and investigations where literal lives may be hanging in the balance. Unfortunately for us, the importance of the investigation does not diminish the complexity of the context in which it is occurring. And so that's the context in which we are beginning to have this conversation. With that, I'm just going to make three brief observations that I'm happy to discuss further as we have our conversation. Number one, I think the Cloud Act appears to be a very welcome but narrow improvement to the cross-border data challenge. Even its authors recognize as much, and I think it does provide some very helpful improvements. Two, the challenge and the threat of data localization will continue. The idea that a country might require that any content generated within its borders be housed and stay within those borders will continue to be a persistent challenge. And then number three, data localization will give rise to a more expensive, less efficient, and less secure internet that will continue to constrain law enforcement cooperation going forward. So those are my brief comments. I'm happy to discuss them further.
So, in a few minutes, I'll open it up to questions, so start to formulate those. So in this particular case, I mean, the Cloud Act may or may not become legislation. I don't think it's going to become legislation in time to moot this case. So Microsoft is making the argument that if the government wins here, that all kinds of other governments are going to be able to do the same kind of thing with, requesting data of U.S. citizens on servers stored elsewhere, and that also other governments might decide that they're just going to require localization of data on their citizens and their servers and not making it available to U.S. law enforcement at all. And the Department of Justice is making the argument on the other hand that, well, gosh, there can be some companies then that can just avoid U.S. law enforcement other than through a very onerous MLAT, Mutual Legal Assistance Treaty process, by just storing data on one of their servers overseas, which they can retrieve within a few minutes for business purposes, but making it effectively unavailable to law enforcement officers. And I'm curious to get your thoughts on how credible you think these arguments are and what kind of a problem this is.
So, I mean, I think these are real arguments because I do think that, there's a little bit of a tendency, and I was guilty of this myself when I was in the U.S. government, to have a somewhat different standard for when the U.S. government, U.S. courts do things than when foreign governments and foreign courts do things, because we know we're good. That's not necessarily universally shared around the world. And I think what we've learned in recent years is that consistency of approach is important. If we hold ourselves to a different standard than others, it does become a problem. I do think that, you have the risk, if in fact you have extraterritorial reach, that it's hard to know where that stops. And it does definitely put the companies in a conflicted position. An interesting question is whether if you went to the owner of the data, who has the right to claim it back, and served the owner with a warrant, could you make the owner bring it back? And the answer to that may well be yes. Now, you get into Fifth Amendment issues if you do that, and you have to talk about active production immunity. But I do think in this case, and I go back to my original analysis, although the data is physically accessible or can be retrieved electronically by the provider, it is just as the Swiss bank can go into the safety deposit box in Geneva and open the box if it has to. The reality is this is not the data owned by Microsoft or by the company. It is data that they are housing on behalf of the owner, and therefore it's like the safety deposit box. We don't allow warrants to be served requiring banks to open safety deposit box in Geneva. So I do think that's the model that I would look at here.
Actually, before Colin, you comment, I mean, certainly if you went to the owner and said, oh, gee, we're going to be searching for your emails, you would imperil potentially the integrity of ongoing investigations by alerting the target to what it is that they're doing. And so the response to that would be, oh, well, that's just what it takes?
Well, there are some circumstances where that would be a problem. I agree. Others, it would not be a problem. I think it depends on the nature of the case. Finally, let me make one other point. We do have MLATs. Now, they are cumbersome, but they're cumbersome because, generally speaking, our prosecutors and the prosecutors in foreign countries treat these as low-priority items, something you get to after you've done all your own cases. One solution to this, putting aside the legislation and the possibility of bilateral agreements, is to simply make that process more efficient, to recognize that in the modern world, nation states who sign these agreements have to be willing to invest what it takes in order to make them efficacious.
Good luck with that. Klon, did you have any thoughts?
Yes, so I'm empathetic with the concern that the status quo and perhaps even a particular decision at the Supreme Court could lead to concerns about data localization, and I mentioned that briefly in my opening comments. I think the reality is I agree with that. I think data localization will also be a persistent threat regardless of how it goes forward. The point being that for those who are able to enter into the bilateral agreements envisioned by the Cloud Act, data localization as a threat goes down. But that's going to be a narrow group, I think, because only a few people are either going to be capable or willing to meet the legal and privacy requirements that those agreements require. Also, quite unintendedly, I think that these agreements will incentivize some countries in the opposite direction. So there might be governments who conclude that they either cannot or will not meet those same privacy and legal standards, and therefore begin to assert data localization requirements as a way of gaining parity and influence in the conversation. And we're seeing that in China now, for example. So I think the reality that we are going to continue to strive against is the internet seems to be taking a lean for a whole host of reasons toward this challenging issue of data localization. The Cloud Act, I think, for its signatories, works very well to help forestall that. But it creates an environment that will also facilitate it for others.
Yeah, you hope when you sort of set a bar that people will head in a virtuous direction, but they might go in the opposite direction.
I think that's a really good point. And I think realistically, we're envisioning that the countries that are likely to be able to satisfy the requirements would be, Western European countries or European countries and maybe some in Latin America. I would not envision China or Russia in that category. But frankly, the issue of localization with those countries is much broader than simply this. And any platform that does business in China and Russia is going to be complying with an increasingly stringent set of demands. Now, I have to say, the Chinese want you to keep all the data about their citizens in China. I'd be stunned if many platforms decided they were going to voluntarily keep the data of Americans in China for all kinds of reasons. So it may be that to a certain degree, inevitably, there is going to be a two-stage array of countries that are dealing with the internet. Those that really keep it more or less open and mobile, and those that do create some degree of localization. And that's, I think, a larger set of issues than just what we're talking about.
So the Cloud Act and ICPA envision entering into these bilateral relationships and depending on standards of privacy protections and identifying the category of cases for which these things will work. And of course, if they do work under the legislation, the foreign government can go directly to the provider, and the provider it could be a robust procedure. But I'm curious of whether, how things like EU privacy laws, which cut across the entire union, might impact that.
I'm the non-lawyer. I'll make a broad comment on that and then turn it over to the real pros. I think it's worth noting that even with the United Kingdom, who I think is arguably the most well-positioned partner as kind of to open the door to these types of bilateral agreements, there are significant differences in our respective understandings of subpoena particularity and admissibility and judicial review and other fundamental legal review notions that are going to have to be worked out. Now, I trust that they probably will, but that does beg the question in terms of, well, what do we do in the meantime? And we're assured that the U.S. notions of those things will govern, but I would imagine that any country who enters into these agreements, if they're worth their salt, are going to try and find the outer edges of these agreements very quickly, which I think might begin to kind of slow these down initially as we work through all that.
I mean, there is a law enforcement exception to the new data privacy rules that are coming into effect in the EU. But the reality is, I think it's correct to say that generally the EU, not uniformly, but most of the countries view us as not as protective of privacy as they are. Nevertheless, in a whole host of situations historically over the last 10 or 12 years, we've managed to work out more or less agreement on these issues such that we're able to function in a whole host of situations where we exchange data, particularly for counterterrorism and law enforcement purposes. So I think it's likely, at least for most countries, and remember, if in Europe, the law enforcement and national security issues are considered nation-state competencies. I think for most countries, we'll be able to work these things out. Now, obviously, if the British execute on leaving the EU, that removes an issue there, although I still think they're subject to some pan-European rules under various conventions. But I'd be optimistic that we could largely work through these problems.
I'm going to ask a broader question that the Microsoft case just suggests. I'm not suggesting that Microsoft in particular has this kind of relationship with the U.S. government, an antagonistic one, although they were on opposite sides of this case. So, we've seen various instances, Apple not wanting to unlock its phone in the wake of the San Bernardino shooting, and there's the whole going dark phenomenon. I mean, you have these very, very powerful, sophisticated tech companies creating all of these platforms and devices that law enforcement increasingly needs to have access to. And I'm curious to sort of put this case perhaps in the broader framework of the relationship at the moment as you see it between sort of the tech community and national intelligence and law enforcement officials, and sort of how you see, either by necessity or by practice, that relationship evolving as these techniques and platforms change. It's a broad question, I know.
No, I think, this is a challenge. There was a piece, I guess, by Bill Gates in the online today or yesterday. It talked a little bit about how the tech companies need to recognize they have to deal with government. It's not, the government is somehow to be disdained. Frankly, I think, if I go back to the period of time right after 9/11, John will remember this. I was head of the criminal division on September 11th, and we immediately got an enormous amount of voluntary cooperation from companies. They're not really so much on the internet stuff, but other kinds of data companies to help us identify other potential terrorists who might carry out attacks. And there had been traditionally a kind of a close relationship between American companies and the American government. To be honest, Edward Snowden did a lot to undermine that. I mean, and I think what he did is he created a level of suspicion and allowed people who, for their own reasons, whether they were ideological or even competitive, to say you can't trust American companies because they are in the pocket of the American government. So I think what happened is American companies, and I can't say this is wrong, said, okay, we'll cooperate with the government, but we want to be punctilious about it. It's not going to be under the table or handshake. It's going to be strictly according to the law, and you have to have, demonstrate you've dotted your I's and crossed your T's before we cooperate and turn something over. I think in general that's a good thing, but I do recognize that it created a little bit of a temperature change in the relationship. I think the larger issue, though, was also to what extent, I don't think I've heard a tech company argue we can disregard a lawful order of a court. They may litigate it, but at the end, if the court comes out a certain way, they're going to obey. A different, larger question which comes up that John mentioned is, to what extent are platforms obliged to organize themselves to make it easier for the government to get things? And there I have to say I'm kind of firmly of the view that companies do not need to organize themselves simply in order to make it easy for them to be able to get things on behalf of the government. If a company has access to data, and assuming all the legal requirements are complied with, then the company should make the data available, should comply with the rules. But if the company configures itself so it doesn't have access to the data, I don't think there's anything wrong with that. Now, I understand that means that maybe you can't decrypt something, or maybe a particular communication will evaporate after 15 or 20 seconds. But there's no requirement that I know of under the Constitution that companies or individuals arrange their lives to make it easy for the government to investigate them. If that were true, I would be required to keep this on all the time in record mode so that if I ever said something that was wrong, the government could immediately subpoena it and convict me of a crime. But we don't make people do that. And I was going to say, back in the day when I was doing organized crime cases, you had warrants that allowed you to surveil mafia figures in social clubs or in other premises or on the telephone. And you know what? They'd turn the radio way up, or they'd leave the room and go walk around on the street. And they were able, and there was nothing unlawful about doing that, even though it interfered with the ability to collect the data. So I think we have to have a healthy respect for the needs of law enforcement, but for the fact that we don't subordinate all of our social and individual liberties in order to simply make it easier.
I completely agree. And I'll just comment briefly on the fact that the tension that you're describing between what I'll call Washington and the Valley is indicative of a broader trend where, because of the capabilities that they're developing and because of, frankly, just their huge user base, there is a migration of the national security burden out of the government sector and into the private sector. And so the type of engagement that we're talking about in terms of law enforcement coming to Microsoft or to Apple or to whomever, that is an illustration of the reality that capabilities that used to exist almost exclusively within the government domain now are existing in an increasingly large order in the private sector. And they have not just the data itself, but they also have the talent to generate that talent. They have the expertise to leverage and use that data. And so I think what the reality is that the tension that we're feeling right now is the federal government is coming to grips with, and frankly slowly, with the reality that it is now a stakeholder in these conversations and not the stakeholder. And then also what I think is beginning to occur, although this realization has been delayed by Edward Snowden and other events, is I think some of the tech titans and just the private sector in general is realizing that it is, whether it wants to or not, now in the position where it is assuming more of those kind of national security and law enforcement responsibilities. And so what we're looking for, and something frankly that I think Heritage is going to be thinking a lot about in the coming weeks and months, is so what does the next grand compromise look like? How do we do this? And I don't know that anyone has a particular answer, but cases like Microsoft v. Ireland and the kind of the underlying data tensions therein are going to be the norm going forward because of those realities of the migrating national security responsibilities.
So with that, let me open it up for questions. Please raise your hand. I'll acknowledge you. Wait for a microphone. Then I would ask you to briefly introduce yourself and your affiliation. Please don't make a speech. And whatever it is you're going to say, end it quickly and with a question mark. Let's start right over here.
So just a quick question. My name is Jonathan Cannon. I'm with Americans for Tax Reform. And my question is, with the two pieces of legislation that are proposed, what do you see as the strengths and weaknesses of each, and how do they compare and contrast with one another?
I mean, just to give, I mean, I'm more familiar with the Cloud Act. I think the issue that I raised is the one that I think is, I wouldn't say it's a flaw, but it's an issue we're going to have to contend with, which is what does it mean to say it's an American citizen's data? Because one thing you would want to do if you wanted to shield your data is you might have data that affected you, but have it held or, quote, owned by someone who's a non-U.S. citizen and then have it housed on a server overseas. I can guarantee you that as soon as you have a rule that is based on distinctions in ownership, people are going to figure out how to manipulate that rule in order to give themselves the maximum protection. So I think this is likely to be the first iteration of what's going to be an ongoing dialogue.
Hi, I'm Tom Bascom. I'm with a company called LinkSpace. As I'm interested in what the current thinking is about the virtual domains and the sovereignty of virtual domains, whether it's a company's numbered domain that can span, internet numbered domain that can span borders, or social network domains, the .coms. What's the current thinking about the sovereignty of those domains that span borders?
Well, it's a great question. I'll simply note that currently we're debating the sovereignty domain of email. And so the thought that we've gotten into thinking about virtual domains is generous, I think, to the conversation, because I just don't think that's the case. I think with email, at least we're talking about, as I mentioned, some of the infrastructure existing in reality, but then being able to track the data and that kind of thing. With VR, I mean, I think that is really around the corner in terms of thinking through the legislative implications of that and how we're going to tackle it. So I would like to think we're further than that, but I don't think we are.
Questions? Don't be shy. Yeah, right here.
Hi, I'm Jared Butcher with Steptoe and Johnson, and thank you for their comments today. One question I had is about the issue of the hurdles that law enforcement face in the real world, the physical world. Transferring those to the virtual world where things move so much faster and there's such a greater volume of data. Does it make sense to still think about the hurdles that should be in place for law enforcement in the same way in the virtual world as we do for the physical world?
Well, I mean, I think, that's a broad question. There are obvious differences. I mean, the whole problem is the data doesn't really live any place. And in fact, for technological reasons, it may literally be moving in the so-called cloud. As one is litigating something, as one's pursuing something, it can be moving around. What remains true, I think, though, in terms of the way nation states view this is I don't get any sense nation states are willing to say this is a domain outside of national sovereignty. And remember, although we talk about the cloud, there's still stuff. It sits someplace in the real world physically. And there's a very strong temptation to say, you know what, if I can grab it with my hands, I own it. So that tension, I think, is going to remain going forward.
The Cloud Act, I mean, one thing the Cloud Act does is it sort of clarifies that constructive possession is good enough, which I suppose will help law enforcement. And another country can object if they believe or have reason to believe that it's somebody else's citizen who's there. And I guess that would also address the issue. I mean, so one of the reasons why Microsoft is involved in this case is because they have a particular configuration in which you can say all the data is housed in one place. But I suppose that does change if you end up having shards of information sort of spread around the world.
Yeah.
And if I might, just on that, there's a rationale to that. It's not as though the companies tried to erect an infrastructure that would be as difficult as possible for law enforcement or intelligence purposes. In fact, it's just the opposite, right? The whole notion of distributed networks and data sharding and things like that, and cloud computing in general, is efficiency and computational power and making that as broadly accessible as possible. And that is precisely what is enabling things like artificial intelligence and machine learning and neural networks and all the things that, by the way, will also be some of the key enablers of future law enforcement intelligence activities. So this is the double-edged sword of technological development. It immediately obliterates many of our legacy notions of sovereignty and territoriality, but it is also, in exponential ways, driving our capacity to provide better law enforcement intelligence capabilities.
So Mike, you would have some insight into this. So Klon said before that the U.S. government is now a participant in these conversations as opposed to the big dog on the block and leading these conversations. And information sharing between the public sector and the private sector used to be, perhaps still is, a massive problem with the government saying, well, you give us everything and we'll give you what we feel like giving you. Now that these private companies are really the dog and the U.S. government is in many senses the tail, how has that situation improved in terms of the give and take?
I think that there's been improvement in this sense. I think the government realizes it needs to approach the tech community in a respectful way, respecting what the tech community wants. But I also think it maybe even more important, the tech community now realizes they're not just independent actors living outside the law, but they have to operate within a legal structure and a social structure to be good citizens. The thing about what's happened in the world of cyber is it has leveled the playing field between countries and between nation states and non-state actors and networks. And that means the monopoly on force you get in the physical world is not necessarily present in the virtual world. And you have to then work in, if I dare say, in a kind of a network to cooperative way. So I think that in some of these respects, you're going to have a more respectful conversation on both sides and more of a desire to reach an arrangement that doesn't fundamentally challenge core interests of either the government or the tech community. And I think those core interests are this. The government's core interest is protecting citizens from violence or criminality or other kinds of harmful activity. The tech community wants to be trusted, wants to be transparent, and wants to be efficient. And therefore, solutions will have to live in that area where you can largely satisfy, not 100%, but largely that distinct, not necessarily adverse, but certainly distinct set of interests.
Anything to add?
Yeah, I think Secretary makes an excellent point, and I think that one of the realizations that is occurring. So Snowden disrupted everything, and it was just a bloodbath in terms of the relationship between Washington and the Valley.
And the public.
And the public, well, precisely. And since then, I think there has been an incremental evolution because a couple of things have dawned on everyone. On the government side, I think they've realized, okay, yeah, we are now just a stakeholder. And in the private sector, they've realized that, you know what, despite our best intentions, we're over the same barrel. One of the impending challenges that I think is going to be decisive is many companies, like the ones we've been discussing today, they count themselves like global entities, and they are in terms of where they operate. But as agreements like this occur, and as other states react to agreements like this, they are going to be increasingly challenged. So I'm going to take China as an example. The way China arranges its economy and the way its government chooses to participate and cooperate with its domestic companies is going to force companies like Microsoft and Apple and Google and others into very difficult positions in regards to how they engage with those companies, those countries. And they may not actually get to enjoy the type of hands-off neutrality that they would prefer, because that would be best for them, but precisely because states are using these as a mechanism of reasserting sovereignty and giving themselves a leg up, giving themselves a greater capacity to compete. And so I just think that there's a clash of worldviews that's occurring, and everybody's trying to figure this out.
I assume that you would see this as the possibility of this, in fact, increasing. I mean, you could readily envision that countries with huge market power like China could sit there and say, the only way you're going to do business is if you refuse to comply with this law.
I mean, they do that now.
And you could wind up with a two-tiered internet in the sense that you could have a set of countries like we've discussed here, Europe, United States, countries in Latin America, that would adhere to basically an open principle with a kind of a common set of standards. And then a country like China might say, okay, we want our Chinese citizens' data held here. And that might be acceptable, but what if they said we want to have all your data held here? Well, I would assume at that point the companies would say no. So you could wind up not necessarily with a dramatic break, but with a migration into a two-tiered system. Now, the argument the tech community, I think, believes in is, in the end, the country that falls to the second tier will hurt its own economy and its own people, and they will pay a price for it. And it may be that's true, or it may be that China is a big enough market that they can do quite well without that. One of the things I will tell you, when I was there a couple of years ago, we talked to them about on the issue of intellectual property theft is there's going to come a time when you guys are doing so much innovation on your own that you're going to become the victims of intellectual property theft. So maybe you want to subscribe to a regime of protecting intellectual property in your own long-term interest. And then you did get the agreement between Obama and Xi, which, while I wouldn't say is observed 100%, at least was a recognition by the Chinese that you shouldn't be using commercial espionage to help your commercial enterprises.
When I worked in doing copyright enforcement in the movie industry, I frequently tried having those discussions with mixed success. There's a question over here. First there, and then we'll go here.
Hi, my name is Tom Dunn. I'm a consultant. Just have a question. When you talk about the sovereignty and data, do you see an increasing role of organizations like the WTO, and will this come into play with more commercial interests and with the various trade agreements in the future?
I mean, I think it does, look, embedded within some of the localization issues is, although it's presented as a privacy issue, often it is a competitive issue. It's a way of sheltering your home businesses. People make that argument sometimes with environmental laws and labor laws and things like that. So I would envision that you will see privacy issues and data protection issues also becoming the subject of trade, negotiation, and dispute.
It certainly even involves corporate espionage, I would say. You've got a hand up over here.
Hi, I'm Samantha Metzger. You discussed Snowden and the Fourth Amendment a lot. I was just wondering, don't we as consumers deserve to know if the government can get a hold of the data that, I mean, we're using towards private companies? Shouldn't that transparency be told to us?
So, I mean, I think, obviously individual applications or warrants don't get disclosed, but there was a debate shortly after Snowden about disclosing the number of times that the government asked for things. And to be honest, I don't really see a problem in doing that. I think part of what happened after Snowden was the government reacted by declassifying with some redactions a number of the FISA court opinions. And I actually thought in the end what was revealed was helpful to the government because it demonstrated that the judges were in fact careful and thoughtful. So I agree, sometimes more transparency can be actually an enabler of doing intelligence security rather than a hindrance.
Yeah, I think it's a fine question. I think one of the realities that over the course of time that we're going to see evolve is I think there's going to be greater transparency between a user and a company because I think that's going to be the necessary buy-in for companies to ultimately have greater transparency with the federal government. I think it's going to be a part of that grand bargain that I mentioned previously.
I mean, I guess I would also just add to that all the authorities are involved here aren't published in secret. They're public laws that you can see. To the extent to which criminal charges are ultimately brought, you can have a judge who's providing oversight in terms of dealing with motions to suppress evidence for violations of procedures. And there is congressional oversight and also within the executive branch and the intelligence community of how these tools are utilized. I mean, look, any kind of transparency is going to involve the honesty of people ultimately disclosing when they access information, and you can get some people, I suppose, who will just not disclose it, who are acting outside the rules. They should be held accountable whenever that happens. The alternative is to imperil the integrity of any kind of ongoing investigation by saying, just thought you ought to know that the U.S. government is now electronically surveilling you, and that's unacceptable. Other questions? Yeah.
Yeah, good morning. I'm Emeric Dupont with the EU delegation here in Washington. I have two questions related to the executive agreements. You mentioned that the UK was first in line to sign an executive agreement under the Cloud Act. Which country do you think could be the next in line after the UK? Which one would make sense? And the second question is, how much do you see from a US perspective the relevance of negotiating such an agreement with the European Union as a bloc instead of negotiating bilateral agreements?
So, I mean, real quick, I would guess the easiest countries to sign agreements with the U.S. would be, Canada, Australia. I mean, that's kind of a long history. I generally think the competencies in this area, particularly law enforcement, are national competencies with the EU. And I can tell you from my own experience, you want to negotiate with a person who can sign an agreement that actually can be executed on, not someone who's simply going to approve it and then say, but I can't really deliver anything. So I think you're going to see mostly agreements with the nation states. The EU may, have some general laws or rules that constrain nation states, but I would guess it'll be nation state by nation state.
Yeah, the only thing I'll add to that is that the EU, almost by definition, won't be able to, I don't think you'd be able to sign an agreement with the EU in bloc simply because you still have a great variety of legal regimes that have to be accounted for.
Other questions? Yeah. Let me ask one more question, then we'll bring it to a conclusion. Is it your opinion, and I realize you have no crystal ball, that regardless of the outcome of the Microsoft case, that there will be a legislative solution of some sort, whether it's the Cloud Act or ICPA or some iteration of that?
Yes.
You believe so, Tim?
I'll be nerdy and quibble with the answer or with the word solution. I think there will absolutely be legislative improvements.
Sure. Good point. I agree.
Please join me in thanking our